Welcome to Module 4, Signs and Instructions. We're getting there. We talked earlier in Module 3 about where you can and where you can't, and I kind of referenced people who have been licensed to carry holders for a while. You may have heard them say 30-06 and 30-07, and they are referring to signs, posted signs on different locations that says what you can and what you can't do with carrying of your firearm. So let's go ahead and jump right in. Module 4, when we discuss signage, right? 30-06 Penal Code, 30-06 signs indicate where concealed carry permit holders can't carry. Doesn't matter if you're invited or not, right? Because people's minds can change, but the law will not in that case, right? So Texas Penal Code 30-06, 30.06, signs indicate locations where you can't carry, okay? Texas Penal Code 30-07 are locations where you cannot carry open, okay? So 30-06, concealed carry, 30-07, open carry. The last slides in the previous module, I talked about 51%, okay? 51% signs that indicate the establishment sells alcohol by the drink and receives more than 51% of its income from alcohol sales. Now, a person who has a license to carry from the state of Texas, they do have a legal defense if effective notice has not been provided. For example, if I go into a building, right, it could be a restaurant or something like that, and I'm totally making this up, so don't come back to me on it. And I do not know by a visible sign that is approved by the state of Texas that signals or indicates to me that 51% of this building business sales are derived from the alcohol being sold by the drink, okay? Then I know that I cannot carry within that building, okay? So it's not a barrier to prosecution, but it is a defense, okay? I could still be, charged or whatnot, but it is a defense, okay, if the sign is not correctly and adequately posted. So the 30-05, as I referenced in an earlier slide, Texas Penal Code 30.05, signs will indicate locations where firearms are prohibited. However, there is a defense for licensed concealed carriers. So if you have an LTC, it is a defense, right? Not a barrier to defense or prosecution, but it is a defense, okay? Therefore, permitless carry of firearms is prohibited, provided no extra signage such as 30.06 or 30.07 are posted. So that's a big difference, right? That's a new sign. So Texas Penal Code 30.05 signs indicate locations where firearms are prohibited. However, it is a defense for a licensed concealed carry permit holder because there's the difference, right, between permitless carry and a person who has a permit. So therefore, permitless carry of firearms is prohibited in that location, okay, provided no additional signs with 30-06, 30-07 have been posted, okay, legally and adequately. Now, Texas Penal Code 46.03 states, pursuant to Section 46.03 Penal Code, places where weapons are prohibited, a person may not carry a firearm or other weapon. Okay, that's important. Okay, we'll talk about that later. Or other weapon on this property. If this sign is posted in a conspicuous location, no firearms are allowed. Okay, and there is also a case to be made that a knife or other self-defense tool could also fall under that. So more to come. Okay, so that is 30-05 and 46.03. So one of the biggest things to note about this, right, is regardless of whatever sign is up on the wall or on the window or whatever, once you receive an effective notice, right? They call it consent, verbal or written notice that entry is prohibited with your firearm, you got to leave, right? You have to, for example, if I go into a building and it has one of those signs, and I'm like, oh, that sign does not pertain to me, for example, because I have a license to carry. And I go in the building and a manager comes up to me and says, you cannot carry your firearm in here. Can't argue with them, right? Because they're going to win. You thank them. You go out to your vehicle, okay, off of the premises, the parking lot, remember, as we discussed before, and you safely secure your firearm, okay? And you can't say, well, I didn't see the sign or whatnot. It's your job to look. It's your responsibility to look. So if someone tells you you can't carry a gun here, even if there's not a sign, you have to leave because they have told you, verbally or written, that you have to leave, right? And a firearm is not welcome in the establishment at that time. So let's talk about specific county or other local restrictions, okay? Because there could be some, right? A municipality, the city, or a portion of the city may regulate the carrying of a firearm at a public park. A meeting of the municipality or the county or a borough government body, a political rally, a parade, or other official political meeting, a non-firearms related school, college, or professional athletic event. And if you look at my note down here, this is very important. Based on an Attorney General opinion, counties may prohibit concealed handgun license holders from carrying concealed handguns in county parks. Let me move my big face out of the way here. And rapid transit authorities may prohibit concealed handgun licensees from carrying handguns while on public transportation. Okay, that could be a city bus, that could be the train, okay, anything like that. So let's say that again, okay. A municipality, okay, your city or whatnot, could say you can't carry at a public park, you can't carry at any city or municipality or county meeting, a political rally, a parade, a non-firearms related school event, whether it be high school, collegiate, professional. And remember that the Attorney General's opinion says counties may prohibit concealed handgun license holders from carrying concealed handguns in county parks or rapid transit vehicles while on public transportation. Okay, and that's Texas Local Government Code 229.001. All right, folks, that's it for this module. Let's take a break, and we'll come back here for module number 5.